For Creamer Media's Polity, I am Shannon de Rehove. Researcher and analyst Professor Raymond Suttner joins me for Suttner's View, a weekly commentary on South Africa's political scene. Welcome, Raymond.
Thank you very much.
Now, the place of traditional leaders and customary law is controversial today, and notice has been given to the minister. That the Minister of Justice will reintroduce the Traditional Courts Bill. What is your view?
It's one of these issues which I am reluctant to come out with yes, no type answers, like some people say, these are the traditions of our people, you must respect them, and just accept that without interrogating it. Or on the other hand, say our customary law very often conflicts with the Constitution, therefore it shouldn't really be promoted. I think we've got to understand that there are a lot of people who do live part of their lives, or all of their lives, or much of their lives, according to customary law. And we have to find a way of accommodating customary law as an equal part of the legal system, not as a subordinate part, not as a marginalized part. And if we say we want to do that, it must conform. The way we say we're going to do it must conform with the provisions of our Constitution, with regard to respect for cultures and customs, with respect to gender equality, sexuality rights, and other things. Now, the way in which I think one can understand what government claims it is doing is to look a little bit at the history, because what they claim they are doing is restoring to traditional leaders and to customary law a status that it had before colonialism and before apartheid. Now, when South Africa was colonized, in some parts of the country, like the Boer republics and the Ciskei, they wanted to destroy the chiefs, and consequently they didn't recognize customary law, and they basically said everyone must fall under the common law, the British law of the time, or the Boer law in the Transvaal, and the Free State. In the then Natal, I can't remember what it was called then, it was the Natal colony, and the Transkei, however, they did recognize customary law, and under Shepstone, they codified customary law in the Natal Code of Native Law. And what that process started was the way, a manner in which colonial and apartheid authorities gave recognition and simultaneously modified the content of customary law in a way that, in my view, or let me say in line with the evidence, impacted negatively on the rights of women. They took the idea from European law that there must be one head of a household, and that was the man, and that all others were dependent on access to property and whatever it is, on whatever that man decided. Now, under customary law of pre-colonial times, women did have some rights to property, and what the result of colonialism and later apartheid controls over what was called native law, later Bantu law, was that law was made more, the patriarchal elements that were there before were made even more excessive. It was very hard for people to escape from marriages. There was one case I read once where a person had been beaten up and told if she came back that she would be killed, and the European administrator, the Bantu Affairs Commissioner, who came to deal with the case, said this did not amount to repudiation of the marriage on the side of the man who kicked her out. Now, after the colonial period, when there was the Union of South Africa, they wanted what they called a uniform native policy. And the Native Administration Act, number 38 of 1927, tried to have a uniform native law, as they called it, or Bantu law later, administered by Bantu commissioners or native commissioners. And these commissioners were supposed to be specialists in customary law. And they were supposed to recreate the atmosphere where people who had gone to the courts of the chiefs or headmen would feel at home. There would not be these technicalities of the European courts. But in fact, these courts were very technical. And if you really wanted to conduct a case successfully, if someone sued you unjustly and you wanted to defend yourself, you really needed a lawyer. And most people didn't have access to lawyers. And these Bantu Affairs commissioners consolidated this approach whereby the law was made even more oppressive for women in particular, and concentrated the powers of the male head. And that was something that went all the way up to the chief, downwards through various ways. It also did not pay adequate attention to differences in custom in different areas, and it tended to freeze customary law, to treat it in the common law. Custom means immemorial usage, what has happened since before anyone can remember. Now, the way in which scholars say customary law should be treated is as a living law. You have situations since colonialism and since apartheid where you have female heads of family. You have lots of female heads of family today. You need to recognize that new custom is being created. So part of the problem of the post-apartheid situation is, while they have claimed to be remedying the wrongs of colonialism and apartheid, they in fact are treating chiefs or traditional leaders as the prime bearers of customary law. Now, in reality, they have very fixed views of customary law, and they've never been the only or even the primary source for what is custom. And they're not sympathetic to this notion of living custom. And unless you're sympathetic to that, you really are going to have a law that does not suit very many people. And this Traditional Courts Bill is one of a number of laws that have come through. They've been trying to pass it since 2008. And what it will do is it will force people to come under customary law. Now, under apartheid, people could actually choose the legal system. They could say, I got married by customary law, I've got married by common law, therefore I would like my case tried in accordance with this. You could opt out of customary law. There were various ways of doing it, although the courts preferred to find that this was a customary law case in most cases, or native law case. But now the Traditional Courts Bill would like all who come under the jurisdiction of a traditional leader to fall under that traditional leader compulsorily. It and other legislation has already been declared unconstitutional. This one might well be declared unconstitutional if it is passed. So my general view is one should not argue that treating everyone the same means that there are no differences. Those people who want to go to chiefs' courts or traditional leaders and follow customary law should be allowed to do it. But we have a duty under the Constitution to ensure that the way customary law develops is in conformity with the Bill of Rights and other provisions of our law.
Speaking of the Constitution, how does the recognition of customary law and traditional leaders square with the current Constitution? And can these ever conform to its provisions given the conservative orientation that seems to be maintained?
Yes, I'm very reluctant to assume that customary law is inherently incompatible with the Constitution, because all that happens if you have a relationship between the Constitution and customary law is that customary law must conform in its provisions with the Bill of Rights and other provisions of the law. And it means that judicial officers, when they interpret that law, must have at the back of their minds that the context is different from before. And if someone claims a right, which may even be a customary right, like ugutwala, some people say it's a right, but ugutwala amounts to forced marriages. That must be struck down. So that would be an example of how it needs to be dealt, as well as taking into account new types of relationships that are now recognized, like same-sex relationships, other forms of sexuality, female-headed households, and so on.
It's interesting. Thank you very much, Raymond.
Thank you.
That was Professor Raymond Suttner speaking to Creamer Media's Polity about traditional leaders and African customary law.